Welcome to the deep dive. If you're listening to this, there's a pretty good chance you felt that. That kind of low hum of modern digital anxiety.
That feeling that someone's always watching.
Exactly. That awareness that, your personal data, your private conversations, maybe even your location, it's all being tracked, analyzed, and sometimes, well, exposed. We tend to frame privacy as this very new problem.
Right, like it's a purely digital age issue, a consequence of smartphones and the internet.
Now, this is the fascinating thing. If you really start digging into legal history, you find a completely different story.
A much, much older story. The idea that your private life, your home, should be inviolable, that's not new at all. It's ancient, it's in some traditions sacred, and the most surprising part is how consistent it is.
That's the paradox, isn't it? That's what gets you. How can these legal systems separated by millennia and vast cultural divides all land on the exact same core legal principle?
That the individual deserves a protected sphere, a space where the state, the ruler, the government just cannot go.
And that's really the mission for this deep dive.
It is. That's the convergence point that our sources really shine a light on, and it's what we want to explore.
Absolutely. So our objective today is to trace this journey of privacy through three major and really quite different legal traditions. We're going to start with the foundational ethics laid down by the Islamic judicial tradition way back in the 7th century.
And then we're going to leap forward in time to the United States, specifically 1965, the landmark Supreme Court case, Griswold v. Connecticut.
Right, where privacy becomes a constitutional right, but in a very unique way. And then finally, we'll look at how a modern nation, Pakistan, chose to guarantee this right explicitly in its own constitution through Article 14.
So we're comparing sacred commands, implied constitutional rights, and these explicit articles. And the goal is to distill that convergent truth.
That timeless truth.
Exactly. To show how the protection of the home, of personal dignity, and the right to make private decisions, well, it forms the absolute indispensable bedrock of justice pretty much everywhere. It's like we're looking at the shared DNA of human dignity across time.
Okay, so let's start at the beginning. Let's unpack this history, starting with what our sources call the sacred command. We need to set the scene here. We're talking about the 7th century, the rise of Islam.
And to really grasp how radical this idea was, you have to understand the world at that time.
What was the prevailing norm?
Well, the context is crucial. In most of the ancient world, especially in tribal societies or, early empires, authority was absolute. Your personal life wasn't really seen as a separate legal sphere.
It was communal.
It was completely communal, subject to intense scrutiny from the tribe, from the ruler,
Oh.
often to maintain social order or moral uniformity or just plain political control. The idea that your home, your private residence, was legally untouchable by the king or the emperor, that just didn't really exist as a widespread enforceable right.
And then suddenly, Islam introduces this a completely different concept.
A radical concept. That privacy isn't just a courtesy or a social norm. It's a fundamental right. It's legal, it's moral, and it's even spiritual.
And crucially, it's enforceable against everyone.
Even the highest authority in the land. And this is where the specific commands in the Qur'an come in. Our sources lay out these three core declarations that create this inviolable sphere. And they are. They're astonishingly concise for such profound legal ideas.
So let's start with the first one, the one that's essentially a ban on state surveillance.
Right. This comes from Surah Al-Hujurat, verse 49.312. And the command is simply, do not spy.
Just do not spy.
Just that. And you have to understand, this isn't aimed at your neighbor peeking over the fence. This is a directive from the highest moral and legal authority establishing a profound anti-surveillance ethic. It fundamentally shifts the burden of interest away from the state and puts a protective wall around the individual.
So the state's curiosity is legally and spiritually reined in.
Exactly. It establishes a duty for the state not to know. The state has to respect that private domain.
Okay, so that's the principle. But then we get to the physical threshold, the front door, what our sources call the world's earliest warrant requirement.
This is pure procedural due process for a physical space. It's from Surah An-Nur 24.27, and it commands, do not enter houses other than your own until you seek permission and greet their inhabitants.
So it's not a suggestion.
Oh, not at all. It is a strict legal instruction. It's procedure. It establishes the principle that the homeowner's right to refuse entry is superior to anyone else's desire to enter, and that includes officials.
And that right to refuse is backed up, right? There's an immediate follow-up.
Yes, in the very next verse, 24.28, it's the immediate compliance command. It says if you're told to leave, you just go back. That is pure for you.
Go back, full stop.
Full stop. The legal implication there is enormous. If permission is denied, the official, whether it's the caliph himself, the police, a moral authority, they have to immediately retreat. The right to privacy isn't up for negotiation at the door. It's absolute at the moment of refusal.
It's just incredible to think that this level of procedural protection for an ordinary person against the state was being codified so early.
The sources really emphasize this point. No legal system before this, not the Romans, not the Persians, no empire or civilization, had made privacy a legal, a moral, and a spiritual right that was enforceable even against the ruler.
And to really see how this worked in practice, we have to look at the key anecdote, the case study, really, the incident involving Umar, the second caliph. We should just note here for listeners, the RA after his name stands for Radiyallahu Anhu, a traditional invocation meaning, may God be pleased with him.
Right. This incident is what takes the doctrine from Scripture, from a holy text, and cements it as binding, enforceable legal precedent. It's the test case.
So let's break down the setup. It's a perfect test of executive power versus individual rights.
It really is. So the story goes that a man was reported to Umar for drinking alcohol in his home, which was prohibited. Now, instead of following the procedure we just talked about, seeking permission, knocking on the door, Umar decided to act immediately. He took matters into his own hands.
He skipped the warrant, so to speak.
He skipped the warrant entirely. He gained entry by climbing over the man's wall. So this was a clear, deliberate physical trespass, an intrusive, warrantless search committed by the head of state himself.
He was trying to enforce the law.
Right, trying to get a conviction, but in the process, he violated those foundational sacred commands against spying and forced entry.
And this is where the story turns. The citizen's response.
Yeah.
It's legendary. He doesn't even argue about the drinking.
Not at all. He immediately pivots to the law. He appeals to procedure. He turns the issue away from his own moral lapse and puts the focus squarely on the state's violation of the law.
What did he say?
He looked directly at the caliph, the most powerful man in the state, and delivered this perfect legal defense. He said, "O Umar, I committed one sin, but you committed three."
One sin versus three.
And then he listed them. He itemized the caliph's procedural violations. He said, "You entered without permission, you spied on me, and you climbed over the wall." His argument was essentially that the state's violation of the core principles of justice, the process, is a far greater sin and a far greater threat to a just society than his own private moral mistake.
That is just a stunning piece of legal jujitsu. He's not defending his actions. He's attacking the legitimacy of the entire process.
He is. And so what was the resolution? Did Umar double down? Did he claim, executive privilege?
What happened?
The complete opposite. This is the moment the doctrine is legally forged. Umar didn't just dismiss the case against the man. He withdrew the entire matter, he apologized for his overreach, and then he delivered the core judicial principle that would govern the state's relationship with the private sphere for centuries to come.
And what was that principle?
He said, "If I violate privacy to enforce the law, then I destroy the law itself."
Let's just pause on that phrase. If I violate privacy to enforce the law, I destroy the law itself. That's the world's earliest articulation of the idea that procedural legitimacy is more important than a single conviction.
It's exactly that. The integrity of the state's process legally outweighs the gravity of the citizen's offense in that specific moment. It's the earliest version of an exclusionary rule in history.
So evidence obtained illegally is tainted.
It's not just tainted, it's void. The case evaporates. It teaches that the means matter just as much as the ends, and that an executive, a government committed to justice, has to be constrained by the very laws it seeks to enforce. By admitting the error and apologizing, Umar cemented this as legal precedent.
So if we pull back and synthesize this whole incident, we can basically extract 5 key legal doctrines that our sources say are direct precursors to modern law.
They flow right from the caliph's actions. First, the clear principle that state officials cannot spy. It solidifies that anti-surveillance ethic. The government doesn't have a right to be curious about your private life.
Okay, that's one.
Second, the idea that private life is protected, it carves out this legally recognized untouchable sphere that's immune from official scrutiny. Third is the big procedural safeguard. Unlawful search invalidates evidence. This is that exclusionary rule we were talking about. If you break the rules to get the evidence, you can't use it.
Which flows from number 4.
Exactly. Number 4 is the practical rule. Home entry requires consent. It reinforces that specific permission, that warrant requirement. No consent, no entry.
And the fifth one is maybe the most profound for society.
I think it is. It's the principle that privacy overrides moral policing. The state cannot use violating your privacy as a tool to enforce its moral code inside your home. It's a fundamental guarantee of personal dignity.
It's genuinely mind-boggling that these 5 principles, which took Western common law traditions, centuries of debate and jurisprudence to define, were just established as foundational legal ethics in the 7th century.
And established so clearly, it positioned the sanctity of the private individual as superior to the raw power of the sovereign. The state is bound by his own process. And that idea right there is the bedrock of constitutionalism itself.
Okay, so now we're going to take a huge leap. A massive cultural and chronological pivot. We're moving from the 7th century caliphate to the U.S. Supreme Court. The year is 1965.
And this transition is so important because it highlights the same fundamental threat, just in a different context: state intrusion into intimate personal decisions. This brings us to the landmark case, Griswold v. Connecticut.
The battleground is totally different, but the core principle is the same.
It's constant. In the 7th century, the state wanted to enforce alcohol prohibition inside a person's house. In mid-20th century America, the state of Connecticut wanted to enforce a specific sexual and reproductive morality inside a married couple's bedroom. The impulse is the same.
The state wanting to intrude on private space to impose its moral code.
Always.
So to really understand the impact of the Griswold decision, we have to talk about the Connecticut law itself. I mean, what exactly was the state trying to legislate?
Well, they were operating under this old, very moralistic legislation from 1879, the infamous Comstock laws. And the Connecticut law criminalized 2 things. First, it made it illegal to use any device or drug for the purpose of preventing conception.
Okay, so a ban on contraception.
Yes, but critically, it went further. It also criminalized counseling married couples on contraceptive methods. So the state wasn't just banning the sale of something, it was making a private conversation between a doctor and a married patient a criminal act.
So it's an intrusion at the level of consultation before anything has even happened.
Precisely. And the Supreme Court, when it struck down this law, used this now famous language. They held that the Constitution protects a zone of privacy within the sacred precincts of the marital bedroom.
That phrasing, sacred precincts, is so powerful. It's almost poetic.
It is. And if you think about that terminology, it's really invoking a concept of untouchability.
Yeah.
It directly echoes that 7th century idea of inviolability. The court was basically saying, this sphere is protected by the highest moral and legal authority we have, which is the Constitution.
But, and here's the crucial difference, unlike the Islamic tradition where the right was explicitly written down, do not spy, seek permission, the U.S. Constitution doesn't have a single amendment that says you have a right to privacy.
Not in those words, no.
So the legal mechanism the court used to find this right was, well, it was ingenious, and at the time, really controversial. The doctrine of penumbra.
Yes. And for anyone not familiar with that legal term, a penumbra is basically a shadow, an unclear area around the edge of a shadow. The court's idea was that the rights explicitly written in the Constitution are the light, and those explicit rights cast protective shadows. These are implied rights that have to exist for the written rights to have any real meaning.
So the court said, okay, privacy isn't written down, but it exists in the zone created by the shadows of other specific guarantees.
Exactly. It's found in their convergence.
So let's break down which amendments the court used to build this right, because it really shows the judicial work that went into it.
They essentially pooled together a collective reading of the Bill of Rights. First, they looked at the First Amendment's protection of freedom of association, the argument being that marriage, the family unit, is a form of private association that the state can't just disrupt.
Okay.
Then they pointed to the Third Amendment, which is the one that prohibits the forced quartering of soldiers in private homes. It seems obscure now, but it's this ancient assertion of the physical inviolability of your house.
That your home is your own.
Your home is your own. Then, of course, the Fourth Amendment, guaranteeing against unreasonable searches and seizures. That's the closest procedural parallel to that ancient command against forced entry. It requires a warrant.
Right.
They also brought in the Fifth Amendment's Due Process Clause, which ensures fair treatment by the state. And finally, and this was really the key that tied it all together, the Ninth Amendment.
What does that one say?
The Ninth Amendment basically says that just because a right isn't specifically listed in the Constitution doesn't mean that people don't have it. It reserves all other unenumerated rights to the people. This was the safety net that allowed the court to say, look, the founders didn't list privacy, but that doesn't mean the right doesn't exist.
So by weaving these 5 different threads together, the court declared that privacy was a fundamental, even though unwritten, right that was essential for liberty. But this wasn't just about finding the word privacy, was it? It was rooted in a much deeper and more controversial judicial philosophy.
It was. This is where we get into the technical weeds a bit with the concept of substantive due process.
Can you break that down?
Sure. The idea is that the due process clauses in the 5th and 14th Amendments don't just guarantee fair procedure, that the state follows all the rules when it acts. It also guarantees that the state cannot pass laws that infringe on certain fundamental substantive liberties.
Like the right to marital intimacy.
Exactly. The idea is some rights are so fundamental to being a free person that the state can't legislate them away, even if they follow all the right procedures to pass the law.
So the controversy wasn't just about birth control. It was about whether the Supreme Court even had the authority to identify and protect rights that weren't explicitly written down.
Absolutely. It led to huge accusations of judicial activism. The central debate became, was the court legitimately identifying a fundamental liberty necessary for human dignity, or were they basically inventing a right based on the personal philosophies of the 9 justices?
A huge debate that's still ongoing today, really.
It is. But regardless of that debate, the impact of Griswold was decisive. It firmly established that the state has to stay out of the most intimate decisions a person can make. It built a constitutional fortress around an individual's decision-making power.
And it really laid the foundation for almost all of the subsequent autonomy cases in the U.S. Cases involving reproductive rights, family structure, bodily autonomy.
They all trace their roots back to Griswold. It secured that sphere of life that is so private and so essential to dignity that the state's moralizing impulse simply has to stop at the door.
And this brings us right back to that core convergence point.
It's uncanny. The methods are worlds apart, right? An explicit sacred command on one hand versus this complex constitutional interpretation using implied rights and substantive due process on the other. But the judicial outcome is identical.
The state has to stay out.
The integrity of private life must yield only to a truly necessary and proportionate reason, not just to the state's desire to impose a moral standard. The 20th century secular court arrived at the exact same conclusion as the 7th century religious legal tradition.
That state intrusion into your private sphere is only okay if there's proof of some kind of external demonstrable harm.
Exactly. The state's interest in enforcing its own internal moral or social norms must give way to the individual's inherent right to dignity and privacy within their own protected sphere. The sanctity of that space is the universal requirement of justice.
Okay, so this brings us to our third legal tradition, which offers such a powerful contrast to the implied rights model we just saw in the U.S. We're now looking at Pakistan, a legal system where the right to privacy isn't found in the shadows of other rights.
Right. It's not derived from judicial interpretation. It's written down explicitly in the Constitution. This gives us a critical third lens to look through.
And this approach, this explicit codification, is pretty common in more modern constitutions, isn't it?
It is. It represents the legal path chosen by many nations, especially those with constitutions written after World War II and the big human rights movements that followed. They basically chose clarity over derivation. They wanted to make these fundamental rights undeniable by writing them directly into the foundational document.
So let's look at the wording itself. It's Article 14.1 of Pakistan's constitution. It's incredibly concise, but also profound.
Article 14.1 states, "The dignity of man and subject to law, the privacy of home shall be inviolable."
That word, inviolable, it's so strong.
It's key. It means sacred, untouchable, not subject to being desecrated or violated. It carries the exact same tone of absolute sanctity that we found in that 7th century Islamic command. It's a very powerful choice of word.
And the structure of the article itself is paramount. It explicitly links 2 concepts that our whole deep dive has shown are inseparable: dignity and privacy.
That direct linkage is the article's intellectual power. It says the protection of the physical space, the privacy of home, is explicitly tied to the fundamental concept of the dignity of man. So the judiciary can't possibly attack the privacy of a home without, at the same time, committed an assault on the inherent dignity of the citizen.
It confirms that shared core reasoning we've been talking about.
It does. It confirms that privacy is the essential prerequisite for human dignity. You can't have one without the other.
Now, the constitutional text specifically mentions the privacy of home, But the judicial system in Pakistan has been really dynamic in interpreting this. They've expanded its protection far beyond just the physical walls.
Absolutely. The Supreme Court's jurisprudence on Article 14.1 shows this consistent commitment to adapting that ancient concept of the fortress to the modern age. We see about 6 key judicial principles that have evolved from this one article.
So let's walk through them. What's the first one?
Well, first, the courts explicitly affirm the exclusionary rule. Unlawful search or seizure voids any evidence found. This closes the loop perfectly between that foundational Islamic procedural justice and modern constitutional law.
So, same principle as the Umar incident.
Exactly the same.
Yeah.
Second, the courts have been very clear that surveillance without a demonstrable legal basis is unconstitutional. This is basically the constitutional version of the do not spy command.
And this is where the courts got ahead of the curve on technology, right? Long before the digital age really exploded.
They did. Critically, in case law from 1996, the Supreme Court established that tapping phones requires legal authorization. This extended the definition of home and privacy from the physical front door to a citizen's private correspondence and telecommunications.
So a phone line is part of the fortress.
It's part of the fortress.
Wow.
The ancient warrant requirement was immediately applied to new technology. The court recognized that a private phone call is just as much a part of your inviolable sphere as your living room.
What's the fourth principle?
Fourth, the judiciary made sure that the scope of privacy is interpreted very broadly. It encompasses family life, correspondence, marriage, and, very importantly for today, digital data. The courts understood that you can't protect dignity by only securing physical walls while a person's inner life, their communications, their data is left exposed.
And the fifth principle connects back to that core idea of dignity.
Yes. The courts have repeatedly ruled that harassment by state agencies violates not just Article 14, but also Articles 4 and 9 simultaneously. State harassment, unwarranted questioning, or intrusion is seen as a multi-pronged assault on a citizen's fundamental dignity and security.
And the sixth and final principle.
It reinforces that privacy includes dignity itself, meaning the inner sanctity of personal life. This protects against psychological intrusion, public humiliation, and the unnecessary exposure of personal affairs, not just physical trespass.
The landmark cases our sources cite really bring this evolution to life. Let's touch on the Benazir Bhutto case from 1988.
Right. That case was instrumental because it tied the right to privacy directly to political freedom. The judgment asserted that the state cannot use intrusive means, like surveillance or harassment, to gather information on its political opponents.
So privacy isn't just about domestic peace.
It's essential for free political thought and action. The court said that undermining a political opponent's privacy is inherently anti-democratic and a direct violation of Article 14.
And then there's the Shayla Zia case from 1994, which is maybe the most expansive interpretation of all. It dramatically broadened the meaning of dignity and privacy of home.
This is a perfect example of judicial creativity in the service of fundamental rights. The case involved citizens who were protesting the installation of a high-power electricity grid near their homes. They were citing potential health risks and environmental hazards.
And how does that connect to privacy?
Well, the Supreme Court ruled that environmental pollution, noise, or any hazard that negatively affects your health, your quality of life, and the peaceful enjoyment of your home actually violates your fundamental right to dignity and the inviolability of your home under Article 14.
So noise pollution can be an unconstitutional intrusion. That's powerful.
It's brilliant. It recognizes that the home isn't just protected from someone walking through the door, it's also protected from environmental degradation that strips you of your peace and dignity. The court effectively said, you cannot make the fortress uninhabitable by assaulting it with external hazards.
And the sources confirm that this trend continues, with recent high court cases affirming digital privacy and protection from cyber intrusion, all under the umbrella of Article 14.
Which brings us back to that consistent judicial analogy used in Pakistan's courts, which is a direct echo of the ancient principle. A citizen's home is their fortress. Even the state cannot enter without strict justification. Whether the source of that right is a spiritual command, a constitutional shadow, or an explicit guarantee, the definition of the inviolable fortress remains the fundamental, non-negotiable legal boundary.
Okay, this is the moment where we bring it all together, the synthesis. We've looked at 3 completely distinct origins for this right. A 7th century sacred command.
A 20th century secular interpretation based on implied rights.
And a modern, explicit constitutional guarantee. And they all lead to the exact same conclusion about the limits of state power.
The pattern is just. It's irresistible. If you look across the comparative table that our source material provides, the function of the law in all three systems is uniform. It really proves that these protections aren't just cultural choices. They seem to be universal requirements for justice.
So let's summarize those shared principles, starting with the source of the right in each system.
Okay, so for Islamic law, the source is the sacred command. It's derived from religious and moral texts, which makes the right inherent and absolute from the very beginning.
Then for the U.S. law, from Griswold.
For U.S. law, the source is the constitutional penumbra. It's an implied right derived from the protective shadows cast by 5 other explicit amendments.
And finally, Pakistan.
And for Pakistan constitutional law, the source is explicit inviolability. It's guaranteed by the written text of Article 14.
Now, why the difference in how the right originates? Why did the U.S. have to rely on this complex idea implication while Pakistan just wrote it down?
That's a great comparative point. The U.S. Constitution is one of the world's oldest, and its initial focus was really on enumerating the powers of the federal government and limiting them. It kind of assumed that basic rights either existed naturally or were protected by state laws.
So they had to interpret their way to the right later on?
Exactly. But modern constitutions, like Pakistan's, were written in a different era. They were heavily influenced by international human rights declarations and that whole post-World War II movement toward guaranteeing positive rights explicitly. So they just build in specific protections like Article 14 to make the right non-controversial and immediately enforceable from day one.
But despite those very different origins, their procedural rules on things like search and surveillance end up being almost identical.
They do. In Islamic law, the rule is simple and absolute. Spying is forbidden. In U.S. law, the Fourth Amendment means state intrusion is heavily restricted and requires a warrant from a judge. And in Pakistan law, the rule is definitive. Warrantless search is unconstitutional, and that protection has been extended from the physical home to digital data.
And the consequence for violating this boundary?
Yeah.
What happens to the illegally obtained evidence? It's the same across the board.
It is. Whether you're talking about the 7th century caliph withdrawing the case entirely, the U.S. Supreme Court applying the exclusionary rule, or Pakistan's similarly judicial principle, the outcome is always the same. Evidence obtained by violating the individual's sanctity is thrown out.
The procedural fairness has to be upheld.
Even if it means the state loses a chance to enforce a moral law. And that procedural requirement, that the state is bound by its own laws, that's the core reasoning, the ratio decidendi, that unites all three systems.
It's the idea that the state must govern lawfully.
Absolutely. If its own actions violate foundational rights, then those actions lose their legitimacy.
Our source material provides this really powerful synthesizing conclusion. Let's just state that core principle one last time.
The universal verdict across all three traditions is this: privacy is the foundation of dignity. A just state cannot intrude into the private sphere without lawful, necessary, and proportionate grounds.
Let's just break down that phrase for a moment. Lawful, necessary, and proportionate. Because that's essentially the modern universal legal test for that ancient warrant requirement.
Right. It means the state needs to meet 3 tests to justify an intrusion. First, it has to be lawful. There has to be a specific law authorizing the action, not just an executive's whim.
Okay.
Second, it must be necessary. The state has to prove there is a critical need to get this information, usually tied to a serious crime or a major public safety threat.
And
third, it has to be proportionate. The level of intrusion cannot outweigh the severity of the alleged offense. You can't, climb a wall or tap every phone in the country just to catch someone committing a minor transgression. The response has to fit the crime.
And that trio of requirements acts as the universal firewall. It protects that individual sphere. If the state can't meet that very high bar, the individual's right to dignity and privacy wins.
And that historical convergence delivers this immutable, timeless truth that just transcends all the legal systems we've studied.
And that truth is, without privacy, there can be no dignity. Without dignity, there can be no justice.
That's the ultimate legal and philosophical conclusion. When you strip a person of their protected space, you're stripping them of their essential self. And once that integrity is gone, the entire legal system is at risk.
This has been such a crucial deep dive. We've traced this incredible journey from that 7th century instruction to simply go back when you're denied entry at a door, all the way to the U.S. Supreme Court's 1965 defense of the sacred precincts of the marital bedroom.
And the underlying message is just this universal, non-negotiable limit on state power.
And there's a profound moral lesson in our source material that feels more urgent now than ever.
It's a warning, really. A home without privacy becomes a prison, and a state without privacy becomes a tyranny.
So justice has this dual mandate. It's not just about protecting public rights like free speech or the right to a fair trial. It must, with equal force, protect what the source calls the sacred quietness of personal life.
Because that inner sanctuary is the wellspring. It's where all our other rights get their meaning. But the difficulty today, the real challenge, is that the nature of intrusion has fundamentally changed.
It's not as obvious anymore.
Not at all. It's easy to spot a caliph climbing a physical wall. It is much, much harder to detect a packet of your digital data being invisibly intercepted, copied, and analyzed halfway around the world. The spirit of the law, the spirit of everything we've talked about today, demands that we extend that concept of the inviolable fortress to every email, every text message, every server that holds our personal data.
And that really leaves us with a final provocative thought for you, the listener, to mull over. A thought that builds directly on that critical procedural lesson from the earliest doctrines we looked at. The 7th century precedent required a physical warrant permission sought at a physical door to protect against a physical intrusion.
Climbing a wall.
Exactly. So, given this evolution from a single physical trespass to instantaneous, massive, and often invisible digital intrusion and data collection, how must that lawful, necessary, and proportionate warrant requirement adapt to truly protect the digital fortress of every citizen in the modern era? What should the process look like when the state wants to cross the invisible threshold of your data?
That is the challenge facing every court, every legislature, and every citizen today. And it's something for you to explore on your own.
Thank you for joining us for this crucial comparative deep dive into the right to privacy.
We'll see you next time on The Deep Dive.